This video is made for educational purposes only and cannot be taken as legal advice. You will find a link to the full judgment in the description. O'Hara v Chief Constable of the Royal Ulster Constabulary, House of Lords Decisions. The 21st of November 1996. Second-hand knowledge supports reasonable belief. The plaintiff had been arrested on the basis of the 1984 Act. The officer had no particular knowledge of the plaintiff's involvement, relying on a briefing which led to the arrest. Held, a reasonable suspicion upon which an arrest was founded need not be based on the arresting officer's own observations. All that is required is a genuine and reasonably based suspicion in the mind of the officer. The test as to whether there are reasonable grounds for suspicion to justify an arrest is partly subjective, in that the arresting officer must have formed a genuine suspicion that the person being arrested was guilty of an offense, and partly objective, in that there must be reasonable grounds for forming such a suspicion. Such grounds can arise from information received from another, even if it subsequently proves to be false, provided that a reasonable man, having regard to all the circumstances, would regard them as reasonable grounds for suspicion. Lord Hope considered what was the level of suspicion necessary to found a valid arrest under the section, saying, "My lords, the test which S. 12(1) of the 1984 Act has laid down is a simple but practical one. It relates entirely to what is in the mind of the arresting officer when the power is exercised. In part it is a subjective test, because he must have formed a genuine suspicion in his own mind that the person has been concerned in acts of terrorism. In part also it is an objective one, because there must also be reasonable grounds for the suspicion which he has formed. But the application of the objective test does not require the court to look beyond what was in the mind of the arresting officer. It is the grounds which were in his mind at the time which must be found to be reasonable grounds for the suspicion which he has formed. All that the objective test requires is that these grounds be examined objectively and that they be judged at the time when the power was exercised. Lord Steyn said, certain general propositions about the powers of constables under a section such as Section 12(1) can now be summarized. 1. In order to have a reasonable suspicion, the constable need not have evidence amounting to a prima facie case. Ex hypothesi 1 is considering a preliminary stage of the investigation, and information from an informer or a tip-off from a member of the public may be enough. Hushen v. Chong-Fook Kam, 1970, AC 942, 949. 2. Hearsay information may therefore afford a constable a reasonable ground to arrest. Such information may come from other officers. Hushen's case, Ibid. 3. The information which causes the constable to be suspicious of the individual must be in existence to the knowledge of the police officer at the time he makes the arrest. 4. The executive discretion to arrest or not, as Lord Diplock described it in Mohammed Holgate v. Duke, 1984, AC. 446, vests in the constable, who is engaged on the decision to arrest or not, and not in his superior officers, and for obvious practical reasons police officers must be able to rely upon each other in taking decisions as to whom to arrest or where to search and in what circumstances. The statutory power does not require that the constable who exercises the power must be in possession of all the information which has led to a decision, perhaps taken by others, that the time has come for it to be exercised. What it does require is that the constable who exercises the power must first have equipped himself with sufficient information so that he has reasonable cause to suspect before the power is exercised. Lord Hope of Craighead.